Good morning, this is your Kelso Report for Monday, April 16th, and I'm your host, Clark Kelso. Pretty light day on Friday. We have an in-bank order in a death penalty case, criminal law decision involving international law, and criminal sentencing. Let's get to our in-bank case first. Last fall, in Carrera v. Ayers, a split panel of the Ninth Circuit affirmed the district court's denial of petitioner's habeas petition, alleging ineffective assistance of counsel, because trial counsel failed to object to the prosecutor's use of peremptory challenges to strike 6 Hispanics from the veneer. The majority reviewed the reasons why the defense counsel might have refused to challenge the peremptory strikes, and concluded that there were in fact good reasons for the strikes in 5 of the 6 instances. The Ninth Circuit has now voted to take this case in bank to determine whether the failure to challenge the prosecution's use of peremptory challenges constituted ineffective assistance of counsel. And now we turn to criminal law involving an international treaty. On November 2nd, 2009, the defendants, 2 Catholic priests, an 80-year-old Catholic nun, and 2 grandmothers, cut their way through 2 fences and into a secure area of a United States naval base near Seattle in symbolic protest against nuclear weapons. They were convicted of trespass and destruction of United States property in excess of $1,000. On appeal, they asserted that the indictment should have been dismissed because the statutory provisions pursuant to which they were convicted were preempted by the 1907 Hague Convention respecting the law and customs of war on land. The 1907 Hague Convention prohibits the attack or bombardment on undefended towns, and especially forbids the employment of arms, projectiles, or materiel calculated to cause unnecessary suffering. Well, defendants argue that this proscription preempted the subsequently enacted statutes that criminalized trespass on United States property and destruction of United States property, at least where that property was used to protect nuclear weapons. The district court denied their motion to dismiss the indictment, and in United States v. Kelly, the Ninth Circuit affirmed. I have a feeling here that defendants' motion and legal argument was intended to be just as symbolic as their original trespass, because the law is so clearly contrary to the defendant's position. In the first place, the criminal statutes were enacted after the convention, and the clear rule is that the most recently enacted provision prevails. International law does not simply preempt statutes. Second, and probably more important, the 1907 Hague Convention doesn't say anything at all about a country's right to possess, store, or protect arms that cause unnecessary suffering. Instead, the convention is limited to the use of such arms on undefended towns through attack or bombardment. Well, our next case involves criminal sentencing. The defendant pled guilty to assault and misprison of felony, arising out of the brutal beating to death of her 6-year-old daughter by the defendant's husband. The defendant stood by outside a room for 30 minutes while the husband beat the child, and then waited for another 30 minutes while the room was silent before the father came out of the room and suggested they needed to get medical aid for the girl. The father and defendant told their young son, who was also in the house, to tell the story that the girl suffered injuries by falling out of a tree. Well, that story fell apart as soon as medical personnel looked at the severity of the daughter's injuries. The district court sentenced the defendant to 37 months in prison with 3 years of supervised release and $13,000 in restitution fines. The defendant argued that the base sentence should not have been enhanced by a finding of use of a dangerous weapon, since the father used a belt to strike the girl, but the district court of the Ninth Circuit rejected this argument, since existing Ninth Circuit precedent holds that a belt can indeed be a dangerous weapon for purposes of sentence enhancement. The Ninth Circuit did modify the sentence, since the statutory maximum for misprison of felony is 36 months, and the district court imposed a 37-month sentence for that charge. The Ninth Circuit remanded for that slight resentencing. And that's it for today's Kelso Report. Have a great day in the law, and get your taxes in by tomorrow.